Welcome to the June 3rd Board of Selectmen meeting at the Village Fire Station. I'd like to call to order to authorize the findings of fact for 48 Rear Langsford Road Wharf and Weir application. I'll have a motion to open.
So moved.
Second.
All those in favor? Aye. Okay. So we have here our attorney, Mark, is going to walk us through the, first of all, everybody's seen the findings of fact.
Yes. Yes.
Everybody's read through them.
Yep.
Okay, so what we want to do is go through them piece by piece, and then let's see if anybody's got, what would you like to do, Mark?
Sure. Just to set the stage a little bit, at the last meeting, there was a vote on the merits of the application, and then a vote to authorize me as the board's attorney to prepare written findings to sort of memorialize and try to incorporate the rationale and reasoning of the board in its vote. And so that's what I prepared and then sent to the board last week, last Friday. And hopefully the board has had a chance to look at that. In the meantime, I had received via email some comments from John on sort of his comments on it. We'll want to talk about those. You want to talk about those in public, at the meeting. I've reviewed them just for my own knowledge. But this, just to reiterate, this is the board's decision. This is not my decision. So this needs to be accurately reflect what the reasoning and the rationale for your decision was to deny the license. So I have included a lot of factual information in here as well. So the goals here are to make sure that everything that's in here is factual and accurate, and also that it accurately reflects the board's decision-making process. So we can go through and I'll sort of leave it up to the board how you'd like to do it. I can either read it into the record, and you can stop me when there's something that you would like to change, or if you have comments about, or we can just sort of go section by section. It's broken into 6 sections, essentially. Whatever, the board, there's no real right or wrong way to do it. And sometimes boards like to have it just sort of read out loud and so that nothing's missed, or save the time and just go to the things that you had issues with. So I'll open it up to the board to see how you'd like to proceed.
Well, I'd like to have it read into the record.
Good. So would I.
And,
Okay.
And so everybody agree that that's what I'd like to do?
Okay.
Let's read it. If you want to read it, or I'll read it, whatever, go ahead.
I'm happy to read it, and sort of as we go, if there, just feel free to stop me. Sometimes I'll note a typo as I go or something like that. But if there's something substantive that you'd like to stop me on and say either that's not right or that's not what we said for our reasoning, then that's the time to stop me. Not wait till the end, because I want you to make sure that all the comments get incorporated in and nobody forgets anything as I go. So
I did have one question, Dave. Do we have anybody else?
Yes.
Okay, we're not taking, I just wanted to make sure we're not taking questions, that's all, okay.
okay, so there's the table at the top, notice of licensing decision, just to make sure I get all this stuff accurate. The applicant, JJWZ LLC, the property location 48 Langsford Road, Rear, tax assessor parcel number 29-1-11, zoning information Cape Porpoise West CPW, shoreland zone SZ, resource protection RP. Review type Wharves and Weirs Act license application, date of decision June 3rd, 2024. So again, like I said, it's broken into 5 sections by letter. Letter A, introduction. Just to sort of set the stage, this matter is before the Town of Kennebunkport Select Board, Board of Selectmen, Board, as a license application under the Wharves and Weirs Act, 38 MRS Section 1022, filed by Eco Analysts Inc. on behalf of JJWZ LLC, Robert J. Zook, Principal, for the construction of a commercial wharf system located in Pitch Pine Cove, the Cove, Cape Porpoise. So I'll refer to the Cove throughout as the Pitch Pine Cove as the Cove throughout. As the municipal officers for the town, the board is authorized by state statute and local ordinance to review license applications for any wharves proposed to be located within the territorial limits of Kennebunkport. At a meeting held on May 23rd, 2024, the board met to consider the application, hold the required public hearing, and vote on the merits of the same. On June 3rd, 2024, the board met to adopt this written decision. The administrative record for this matter consists of the following documents, and this is a bulleted list. Bullet 1, application filed by Eco Analyst, Inc., 283 pages, including attachments, dated April 26, 2024. Bullet 2, various written public comments filed by the individuals listed in the attached Appendix 1, which I'll get to at the end of that list. Bullet 3, DMR Wetlands Alteration Project Review, dated March 30th, 2021, offered and admitted at the public hearing by the applicant. Bullet 4, enlarged copy of plan included at page 61 of the application, marked up in hand by the applicant's consultant at the public hearing and admitted at the public hearing. Exhibits, and last bullet, exhibits A through C, submitted at the public hearing by Sean Turley, attorney for Gary Eaton, and Terry Ridlin Stevens, daughter of Gary Ridlin. Anything that I missed in terms of what the administrative record consists of? Okay. Letter B, findings of fact. The board finds that the following facts are supported by evidence in the administrative record, which is composed of the documents referenced above, as well as the testimony received at the public hearing in this matter. Number 1, the applicant is JJWZ LLC, paren applicant, a Maine limited liability company duly organized and in good standing, with a mailing address of 128 Log Cabin Road, Arundel, Maine, 04046. Number 2, the subject property is located at 48 Langsford Road rear and is designated on the town's assessing records as parcel number 29-1-11, paren property. Number 3, a complete application was submitted to the town on April 26, 2024. Number 4, the town provided notice of the application to all property owners within 200 feet of the property, which are A, Gary Ridlin, parcel number 29-1-10, who was a direct abutter. B, town of Kennebunkport, parcel numbers 29-1-12 and 29-1-3, which is a direct abutter. C, Christopher and Shannon Ellis, parcel number 29-1-13. D, Harold and Louise Mooney, parcel number 29-1-6. Gary Eaton, parcel number 29-1-7. And Victor and Jenny Hutchins, parcel number 29-1-9. 5, the board conducted a site walk of the property on May 20th, 2024, which was attended by the board members, town staff members, the applicant's representatives, and various members of the public. The purpose of the site walk was to view the property and the location of the proposed wharf in context with the surrounding properties. 6, on May 23rd, 2024, the board held a duly noticed public hearing at the village fire station to hear the applicant's presentation, to receive comments from members of the general public, and to deliberate on the merits of the application. The applicant was represented at the meeting by its consultant, Harold L. Brown of Eco Analysts, Inc., along with the applicant's attorneys, Sandra Gay and Jean Libby. The board was represented by Mark Bauer of Jensen Baird as special counsel to the town. 7, following the applicant's presentation, the board received public comment from the following individuals. A, Sean Turley, attorney for Terry Ridlin Stevens and Gary Eaton. B, Terry Ridlin Stevens. C, Gary Eaton. D, Harold Buzz Mooney. E, Bill Goodwin. F, John Green, paren owner of Langsford Lobster and Fish. G, Glenn Oakley. H, Marianne Sorge. 8, after closing the public hearing, the board deliberated on its decision and voted to deny the application for a wharf license by a vote of 3-2. 9, the board then met on June 3rd, 2024 to deliberate on this application and to adopt the findings of fact and conclusions of law contained herein. 10, the applicant has demonstrated adequate right, title, or interest to the location of the proposed wharf, paren, intertidal zone area of the property, close paren, by providing a survey from Lower Village Survey Co., LLC, that's page 5 of the application, and a deed from Robert J. O'Reilly and Waltrud Anna Sigfridsberger to the applicant dated August 2nd, 2016, and recorded in the York County Registry of Deeds in Book 17289, page 264, page 8 of the draft planning board application appended to the application. 11, prior to filing its application with the town for the proposed wharf, the applicant obtained a permit from the Maine Department of Environmental Protection, DEP, under the Natural Resources Protection Act, NRPA, dated March 9th, 2023, and a permit from the U.S. Army Corps of Engineers, USACE, dated December 28th, 2021. Application at 15 and 29. 12, the applicant proposes to develop a commercial wharf and pier system consisting of an elevated deck, 8 feet wide by 24 feet long, permanent pier structure, 4 feet wide by 45 feet long, ramp, 4 feet wide by 20 feet long, and float, 4 feet wide by 60 feet long, for a total length of approximately 113 feet. There's a footnote at the end of that sentence. The footnote reads, at the public hearing, there was some confusion about the actual length of the proposed wharf, as Mr. Brown initially represented that it would be 133 feet long, and for the site walk, he had set markers at 133 feet. However, at the public hearing, Mr. Brown conceded that the proposed wharf is actually 113 feet long, as described in the DEP's description of the project. See application at 17. End of footnote. Number 13. According to the applicant's estimates, the proposed wharf would only be usable for 4 summertime days, 2 hours per day, for a total of 8 hours over the next 2 years. Application at 62. However, the proposed wharf would remain in place when not in use. 14. The proposed wharf as designed would be oriented perpendicular to the thread of the channel in the cove and is depicted on a plan included in the application. See application at 61. According to that plan, the proposed wharf would leave just 94.5 feet between the end of the wharf and the buoy marking the ledges on the other side of the cove. 15. The proposed wharf is to be constructed upon the intertidal zone, i.e. the area between the normal high water line and the normal low water line, also referred to as the tidal flats of the property. 16. There is a public boat ramp owned by the town and located on parcel number 29-1-3 in the cove, which is available for use by the general public on 30-minute increments that are reservable in advance. According to testimony at the public hearing, the public boat ramp is widely used and serves up to 5 boats per day during the summer season, depending on the tides. Boats that are launched from the public boat ramp would need to navigate around the proposed wharf in order to exit the cove to reach open water and to return at the end of the day. 17. There was a marine railway owned by Green Marine Corp., DBA Langsford Road Lobster and Fish House, located at 42 Langsford Road, parcel number 29-1-4, which is the only marine railway in Cape Porpoise servicing commercial boats in the area. According to written comment and testimony by owner John Green, the business hauls approximately 25 boats per year on the railway for maintenance, and those boats access the railway through the narrow channel in the cove. 18. Gary Eaton owns the property at 46 Langsford Road, parcel number 29-1-7, where there is a historic fish house. His family uses the cove for a day sailor, a skiff, kayaks, and stand-up paddleboard, SUP for abbreviation. In his written comment, Mr. Eaton included a diagram of a typical route for his day sailor, which passes through the intertidal zone of the property. 19, abutter Gary Ridlin owns the property immediately adjacent to the property with frontage on the cove. Through written comment and testimony at the hearing, Terry Ridlin Stevens, Gary's daughter, stated that they used the cove for launching boats and small watercraft such as SUPs, kayaks, and canoes, and that they also navigate over the intertidal zone of the property. 20, All public comment received by the board in writing and during the public hearing, other than the applicants, was in opposition to the proposed wharf, principally citing concerns about the obstruction to navigation that would result from its construction on the property as designed. So that's the last paragraph of the factual findings, or findings of fact section. Before I move on to letter C, just wanted to see if there was anything in there that needs to be corrected factually, or that I left out, or needs to be added.
I had just one question. On item number 13, Mark, we stated the application of the summertime days. Is the intent there just to sort of bracket it into the summertime hours and not to reference that it will be used in the wintertime?
I'm sorry, where are you?
I'm sorry, item number 13.
Okay. According to the applicant's estimates, the proposed wharf would only be usable for 4 summertime days. This was taken out of that section of the application, that page.
that's what was stated.
I think the testimony was that it would be used other than that, sort of outside the summer. So is that what you were proposing, to add something that would be used other times of year as well?
Yeah, I just didn't know the intent of that number 13, because it sounds like it was only going to be used 2 hours, that time per the summer. But we heard from the applicant during the public hearing that their intention is to use it during the winter
Okay.
also.
So I'm happy to add, what do you think would be they can add this to number 13, if you want to
I
propose some
think the
wording.
statement was correct, that it's still, you can put wintertime in there, but the number of hours and the days that was specified during the year was 2 days in one year and 2 days in another year. Didn't specify whether it was summertime or wintertime, just said days, if I'm not mistaken.
If
So
you want me-
No, I believe it was during the summer, it was those times.
I think we need to look at that, because
Okay.
I think that it just said per year.
if you want, I can just read from the,
I think it said,
Okay.
yeah.
so this is from page 62 of the application that was submitted. This is section 2.4. The following assessment is very conservative, disregarding foul weather days, rain and/or fog, and accepting that every day is potentially available to boating traffic to occur. The 4 usable summer daytime tides out of 60 available days in the next 2 years are only 1.6% out of the 244 total days. Furthermore, the boats can only use the floats for approximately 2 hours on those days for a total of 8 hours in 2 years.
That's where I got the years thing.
Using 10 hours a day,
Summertime.
using 10 hours a day for the 244 days. For both summer seasons, those 8 hours only represent 0.33% of the total time, come rain or shine. So it seems to me that was sort of designed to just talk about what the summertime days were. And I think if is it the recollection of the board that there was testimony that the float or the wharf system would be used at other times of the year as well?
Yes, in the shoulders, yes,
Okay.
there was.
Leave it to you guys then. Yeah, because my memory is,
No, I'm
Yeah.
pretty clear, that was the
Alright.
thing, that they would have more access, their larger tides, and at least the statement was that they felt they would have more access and more days in the shoulder seasons. It's still darn limited, but, yep, that was their statement.
okay.
The 4 hours was definitely just during the summertime.
Okay.
Okay. So what if I were to say, and again, this should be the board's words, but in addition to those summertime days, the applicant will make use of the proposed wharf during other times of the year? And I wasn't sure how to quantify that. I don't know that there was testimony
I
on
think
that.
that's fine. I think what I was, because I think the point that was trying to be made was, the potential conflict during summer hours. So that point, but I just didn't want to lose
Yeah.
the point of the applicant having access and use, the wanting of using it in the winter.
Okay. Nope. That's good comment. Okay. Anything else on the findings of fact before we move on? Okay, so, letter C, legal standard. Under the Town of Kennebunkport zoning ordinance, quote, any new permanent, temporary, or material expansion or alteration of a pier, dock, wharf, bridge, or other structure or use extending over or below the normal high water line of a body of water or within a wetland shall require a site plan review and approval by the planning board, end quote. That's Kennebunkport Maine Code, section 240-5.11, and a footnote to that sentence. In addition, section 240-4.14B of the zoning ordinance specifies that planning board approval is needed for, quote, piers, docks, wharves, bridges, or other structures and uses extending over or below the normal high water line of a body of water or within a wetland, end quote, in accordance with chapter 240, article 10, planning board site plan review. End of the footnote. However, that same provision directs the Board of Selectmen to, quote, review and approve the proposed project according to the procedures and standards set forth in 38 MRSA sections 1021 through 1027 before the application may be submitted to the planning board, end quote. The statutory sections referenced in the ordinance language quoted above comprise Maine's Wharves and Weirs Act, paren, the Act, close paren. Section 1022 of the Act provides that if, after inspecting the property and holding the public hearing on the application as required, the board decides that the erection or extension of a proposed wharf would not, quote, would not be an obstruction to navigation or injury to the rights of others, and then an ellipsis indicating that this word's omitted, they shall issue a license under their hands to the applicant, authorizing the applicant to make such an erection or extension and to maintain the same within the limits mentioned in such license, end quote. 38 MRS section 1022. The board will not issue a license for an application that does not meet that legal requirement. For the first element of the legal standard, whether the proposed wharf would be an obstruction to navigation, the statute does not define the term obstruction. Therefore, the board will apply the plain language meaning of that term and will look to dictionary definitions for guidance. Black's Law Dictionary states, quote, as applied to navigable waters, to obstruct them is to impose such impediments in the way of free and open navigation that vessels are thereby prevented from going where ordinarily they have a right to go or where they may find it necessary to go in their maneuvers, end quote. Black's Law Dictionary further defines the phrase, quote, obstruction to navigation, end quote, to mean any, quote, any unnecessary interference with the free movement of vessels, end quote, and generally defines obstruction as a, quote, hindrance, obstacle, or barrier, end quote. The board finds these definitions to be useful in its interpretation of the plain language meaning of the phrase obstruction to navigation. For the second element of the legal standard, whether the proposed wharf would result in an injury to the rights of others, Maine courts have interpreted the phrase rights of others to include the public rights under the Colonial Ordinance of 1641 as amended in 1647. The Colonial Ordinance allows landowners whose property adjoins tidal flats to own the flats to the low water mark, subject to certain public rights in the intertidal zone. Those public rights are typically summarized as the rights of fishing, fowling, and navigating in the intertidal zone. See Bell versus Town of Wells, 557 A. 2nd, 168, 173, Maine, 1989. In addition, Maine courts have considered the rights of others in 38 MRS section 1022 to include the rights of riparian owners, i.e. those owners of land abutting a body of water, which are, quote, one, the right to have the water remain in place and retain as nearly as possible its natural character. 2, the right of access to the water. 3, subject to reasonable restrictions, the right to wharf out to the navigable portion of the body of water. And 4, the right of free use of the water immediately adjoining the property for the transaction of business associated with wharves. Britton v. Donald, 2011, Maine 16, paragraph 8, 12, A. 3rd, 39, emphasis added to some of the language. Therefore, the right of a riparian owner to wharf out is not absolute, as it may be limited by reasonable restrictions. For its consideration of injury to the rights of others, the board will take into account both the public trust rights in the intertidal zone, fishing, fowling, and navigating, as well as the private rights afforded to riparian owners under the common law. That's the end of section C. Before I move on, anything to clarify or anything to add on that section? Okay. And now D, conclusions of law. As explained above, the question before the board is whether the applicant has demonstrated that the proposed wharf would not be an obstruction to navigation or an injury to the rights of others, 38 MRS section 1022. At the hearing, the applicant's representatives made reference to the applicant's common law right to wharf out as a riparian owner. However, as noted above, that right is not absolute and is limited by the provisions in the Wharves and Weirs Act. Therefore, a riparian owner has the right to wharf out, provided that it has demonstrated that doing so would not obstruct navigation or injure the rights of others. Based on the facts stated above as applied to the legal standard in section 1022, the board concludes that the applicant has not satisfied his burden of proof in this regard for the reasons set forth below. And then number one is obstruction to navigation. For the first part of the legal standard, the board concludes that the applicant has failed to demonstrate that the proposed wharf would not be an obstruction to navigation based on the evidence presented to the board. The record contains ample evidence that despite its small size, the cove is widely used by boaters, including owners of commercial boats up to 25 that access the marine railway owned by Green Marine multiple times per season, and recreational boaters launching a variety of types of watercraft, skiffs, sailboats, kayaks, canoes, and SUPs, from the public boat ramp or from privately owned parcels of land abutting the cove. The 113-foot-long proposed wharf, which would be oriented perpendicular to the channel, would cut off a significant portion of the usable water in the cove, leaving just 94.5 feet between the end of the wharf and the buoy marking the ledges on the other side of the cove, and forcing those users of smaller watercraft to operate them within an exceedingly narrow area between the end of the wharf and the ledges on the opposite side of the channel. The creation of such a bottleneck at the mouth of the cove would result in a hindrance or obstacle, those terms being in quotes, quote, hindrance or quote, obstacle, such that the board finds that the proposed wharf would create an obstruction to navigation. Moreover, the proposed wharf would undoubtedly prevent the members of the public who testified from going where ordinarily, a quote, from going where ordinarily they have a right to go or where they may find it necessary to go in their maneuvers, end quote, to use the wording from the dictionary, the definition in Black's Law Dictionary. Anything in that paragraph before I move on?
That's it. Nope.
Okay. For its argument on navigation, the applicant relied primarily on the findings contained in the permits issued by DEP and the U.S. Army Corps of Engineers, which are included as attachments to the application. See application at 15 to 34. On the issue of navigation, the DEP concluded that the proposed activity will not unreasonably interfere with the existing recreational or navigational uses of the coastal resource, provided no construction takes place from May 1st to September 30th of any given year, end quote. Application at 22. The U.S. Army Corps of Engineers permit states that the project, quote, will have only minimal individual and cumulative impacts on waters and wetlands of the United States, end quote. Application at 29. The board recognizes that the DEP and U.S. Army Corps of Engineers have concurrent jurisdiction over the proposed wharf, but determines that the board is not required to defer to the conclusions reached by those agencies on the question of navigation as regards this license application. The board also notes that the statutory standard under the Wharves and Weirs Act, 38 MRS section 1022, quote, obstruction to navigation, end quote, differs somewhat from the standard applied by the DEP for the NERPA analysis, quote, unreasonably interfering with existing navigational uses, end quote. The board is not required to determine whether the obstruction is unreasonable or not, but rather whether an obstruction to navigation would result from the proposed wharf.
Good.
The applicant also argued that the proposed wharf would not obstruct navigation because it will be covering an area where there is submerged ledge, implying that the intertidal zone area is not currently navigable. However, the record contains evidence both through written comment and testimony at the public hearing, which the board finds credible, that the area with submerged ledge is currently navigable by boats that do not draw a lot of water, like day sailors, kayaks, paddleboards, and other small watercraft. Anything to change there?
Yeah, I have one thought there. I might strike the day sailor. The day sailor has a centerboard or rudder. That's really not one that qualifies for low water. The wharf, in my opinion, is a factor for day sailors, but that will come up later. That one, I would just suggest striking day sailor because it's not a boat that does not draw a lot of water. If you follow my double negative.
I do. My only question is that I thought that I heard testimony, maybe I'm wrong, I just, on the proposed routes for the sailboat from the Eaton property went, sort of jig-jag, and it went,
That's for navigation, but they're staying in deeper water when they're tacking like that. So that's not, that will come up later, and I want to bring that
Okay.
point, because I think it's a major point.
okay. So, but for this section here, you don't think there are any sailboats that are navigating over that ledge? Is that what, or that's,
No, I
the
don't.
testimony was not that you recall that there were any sailboats using that area?
No, there was testimony that some people were leaving, using that area and the
If
routes
you wa-
that they showed. I mean, it was right across it.
That do not draw a lot of water, to me, is contradictory to the sailboat. I mean, that's,
Well, should that phrase come out?
But a small sailboat is a lot different than.
Yeah, and that's what they were
the
talking
larger.
about.
And it.
All right, fair
it will
enough.
go down in.
if you're
but
talking 3 feet of water or something of that,
yeah,
that's
it's not-
fair.
it's not like a
Certainly not a
20-foot boat.
lobster boat, that's a
Right.
fact. All right, that's fair. Good enough.
Okay, I just wanted to
problem.
make sure,
No
we're
problem.
all on the same page, because I was trying to tie it to evidence that was in the record, so. So then to sort of further that, for example, Sean Turley's letter dated May 16th, 2024, figure 3 at page 3, and there's a footnote here. Attorney Turley also submitted enlarged versions of these diagrams at the public hearing, which were labeled Exhibits A through C, end of footnote. Includes diagrams of typical routes for the Eaton's sailboat and the Ridland's kayaks / SUPs, showing how these routes will be blocked altogether by the proposed wharf, forcing those boats into the channel where larger boats navigate. Similarly, figure 5 at page 11 depicts likely routes from the public boat ramp and the marine railway to exit the cove and demonstrate how narrow the opening would be between the end of the proposed wharf and the buoy on the opposite side of the channel.
So I
Any
have,
comment there?
I have a question for Mark and the rest of the board. Per our recollection, I think when everyone was given testimony, wasn't it noted on that specific item? I'm just recalling it now, on that specific diagram, that was drawn out at the 133, that was the first application to the DEP, not the second, when they
Yeah,
drew do we have to note that, or?
well, I put a footnote 4 there. I think, so footnote 4
Hello.
is the board, and see if this answers your question, Mary Ann. The board notes that, or Mary Beth, sorry. The board notes that exhibits A through C depict the distance of the proposed wharf as 125 feet, while the actual length is 113 feet.
Yep.
Just to sort of
Yep.
note that
Thank you.
was an error in those
Got it.
exhibits, but.
Yep, thank you.
Okay. All right, next paragraph. The applicant's other main argument with regard to navigation is that its use of the proposed wharf will be very limited, estimated to be just 4 days, a total of 8 hours over the next 2 years. And I think ties into what we were talking about before. That needs to be modified, I think,
That's
so,
what I want
okay.
modified.
So before we move on, let me just make that change.
Be very
just
limited.
For
during-
summertime days, right?
During the summer months is what I would say, estimated to be. Be very limited during the summer months.
Okay, so I'll just reread the sentence. So the applicant's other main argument with regard to navigation is that its use of the proposed wharf will be very limited, estimated to be, will be very limited during the summer months. estimated to be just 4 days, a total of 8 hours over the next 2 years, and that such limited use would not injure the rights of others. Is that
Correct.
revised version? Okay. The board does not find this argument to be convincing based on the evidence in the record. In the board's view, the obstruction to navigation arises primarily from the existence of the proposed wharf itself as a 113-foot-long protrusion into an already small cove, rather than the usage of the proposed wharf by Mr. Zook's boats, however limited. Anything to change about that paragraph further? Okay.
I think that's probably all right. I had said to both public and the abutters, but I think that's, I mean, during the summer months, but it's still, I don't know if it needs to be stated during this. I mean, during the summer months is obviously the concern. That's when the cove is used.
However,
Public and-
however, to end that paragraph saying however limited during the summer months, is that what you mean?
Yeah, the same
Okay.
one. The board does not find this argument to be convincing based on the evidence in the record. In the board's view, the obstruction to navigation, and that I added to both the public and the abutters, arises primarily during the summer months from the existence of the proposed wharf itself. Because that's when it arises.
Are others in agreement with that change that John just expressed?
Read that again, John, please.
The board does not find this argument to be convincing based on the evidence in the record. In the board's view, the obstruction to navigation to both the public and abutters arises primarily during the summer months from the existence of the proposed wharf itself. So it's the wharf being there that is creating the issue, as the 113-foot protrusion is or in a small cove rather than the usage, et cetera.
Does Johnny Green do any much in the wintertime with the railway?
I'm sorry?
Does Johnny Green do much in nothing? Close.
But the shoulder seasons,
good.
he sure does.
Yeah.
I mean, that would be true in the
Exactly.
shoulder seasons, so fall and
In the
spring,
fall and spring,
he'll access it.
yeah.
So that's
It's closed 4
true.
or 5 months, well, 4 months out of the year.
It's still just the protrusion that's the obstruction. So I think it's inferred that whether it's the abutters or whether it's
That's-
the public,
That's fine.
yeah,
I'm-
I think it,
Okay.
We
Yep.
just let it sit.
So I think I have it the way that John just expressed it. If
Okay.
everyone's are good with that language, then I'll keep it that way, or?
No, I think we're talking
No, I
about
think
putting
we'll
it
take
back.
the public and the butters.
I think they have overruled.
Oh, because of the fact that it may be used other times of the year besides just the summer?
Yeah, and it's inferred that it's there during the summer, and
it's
that's
anybody
fine.
who's using it.
That's fine.
Okay,
I'm not bent over it on it. Just-
okay. So I'll just
to
put
be
it back
clear.
the way it was, but I will still change that first sentence to make clear that it's the proposed use of the proposed wharf will be limited during the summer months, right?
Right.
Okay.
Yes.
Yes.
So I'll keep that the way it was. And then the last paragraph here, finally, the applicant's representatives asserted at the public hearing that the proposed wharf would not be a quote, unreasonable obstruction to navigation. The board concludes that those assertions misstate the legal standard under the Wharves and Weirs Act, which does not include the word unreasonable. And then a footnote 5 here. In contrast, for example, the NERPA standard applied by DEP is whether the proposed activity will, quote, unreasonably interfere with existing scenic, aesthetic, recreational, or navigational uses, end quote, 38 MRS section 480-D1, emphasis added. And then the last sentence, or last two sentences, rather, the question under 38 MRS section 1022 is simply whether the proposed wharf would be an obstruction to navigation. For the reasons stated above, the board concludes that the proposed wharf would undoubtedly be an obstruction to navigation. And that's the end of sort of section 1 on the first part of the legal standard. Before moving on, is there anything that people saw that needed, in addition to what we already talked about, to be changed or added, or? Okay.
Okay.
Moving on to number 2, injury to the rights of others. For the second part of the legal standard, the board concludes that the applicant has failed to demonstrate that the proposed wharf would not cause injury to the rights of others based on the evidence presented to the board. The, quote, rights of others, end quote, in the act is a reference to 1, the public trust rights to fish, fowl, and navigate in the intertidal zone, and 2, the private rights of riparian owners for those parcels abutting a water body. First, on the public rights, the board concludes that the proposed wharf would result in an injury to the public right to navigate across the intertidal zone area where the proposed wharf would be located. The board found credible the testimony of the users of the cove, including Gary Eaton and Terry Ridland Stevens, who each stated that they have historically navigated across the intertidal zone portion of the property using different types of watercraft, day sailors, skiffs, kayaks, and SUPs, and that members of the public using the public boat ramp also have done so. Accordingly, the evidence in the record supports a conclusion that the proposed wharf would be an injury to the public's right to navigate in the intertidal zone area of the property. Anything on that paragraph before we move on? Okay. Second, on the private riparian rights, the board heard testimony and received public comment from numerous riparian owners in the vicinity of the property: Terry Ridland Stevens, Gary Eaton, Harold Mooney, Bill Goodwin, and finds that evidence to be convincing. That evidence demonstrates that the proposed wharf would extend out 113 feet along the entire easterly boundary of the Ridland parcel's intertidal zone and would extend across the entire width of the Eaton parcel's frontage, thus resulting in an injury to both owners' right to access the waters beyond the cove. As the applicant's attorney stated at the public hearing, the Wharves and Weirs Act is designed to prevent one owner from blocking another owner with a wharf. That is precisely what would occur if the applicant were permitted to construct the proposed wharf on the property. Therefore, the board concludes that the proposed wharf would be an injury to the right of access to the water for the owners of the Eaton and Ridland properties. Anything to change with that paragraph? Next one, the applicant argues that as a riparian owner itself, it has the right to wharf out to navigable waters. While this is true, the law court has instructed that the right to wharf out is subject to, quote, reasonable restrictions, end quote, and that the riparian rights in general, quote, have long been subject to reasonable regulation by the state to protect the public's rights pursuant to the public trust doctrine, end quote. Britton v. Donnell, 2011, Main 16, paragraph 8, 12A, 3rd, 39. As noted above, the board concludes that the public trust rights would, in fact, be injured if the proposed wharf were constructed. The board interprets the Wharves and Weirs Act to provide a reasonable limitation on the wharfing out rights of riparian owners in order to protect the public trust rights and the rights of other waterfront property owners in the vicinity. The board concludes that the applicant has not met its burden to demonstrate that it could construct the proposed wharf without injuring the rights of others, and therefore fails to meet the second part of the statutory standard in 38 MRS section 1022. Anything? So that's the end of this section on injury of the rights to others. Anything, any other comments on that section?
It's okay.
Okay. And then section E, decision. Based on the foregoing, the board concludes that the applicant failed to meet its burden to demonstrate that the proposed wharf, quote, would not be an obstruction to navigation or injury to the rights of others, end quote, as required by the applicable statute, 38 MRS section 1022. Therefore, by a vote of 3 in favor, Weston, Matthews, Bold, Dykstra, and 2 opposed, Daggett, Gilbert, the board denies the application for a license under the Wharves and Weirs Act. And then letter F is appeal. Any party aggrieved by this decision shall have the right to appeal to the Superior Court of the State of Maine within 10 days of the mailing of this notice of decision in accordance with 38 MRS section 1022 and Rule 80B of the Maine Rules of Civil Procedure. And I'll just note at the bottom, I have it set up as the chair signing. You can have it set up to have all of you sign it if you'd prefer. I didn't know what the board's normal practice was on decisions. But if you do have the chair sign, they'll just need to vote to authorize the board, the chair to do that. So anything else to discuss about? Oh, sorry. There is the appendix 1. I might as well just to close the loop on that. This was the list of so appendix 1, list of individuals filing written comments, and I'll just run through those to make sure I haven't misspelled anyone's names or gotten them wrong. So, 1, Sean R. Turley, Esquire, on behalf of clients Gary Eaton and Terry Ridland Stevens. 2, Walter Brassert, 34 Langsford Road. 3,
Maya.
Jansen, and Paul Bushkowitz, 17 Langsford Road. 4 was just concerned residents, it was anonymous. 5, Gary Eaton, 46 Langsford Road. 6, Scott Eaton, 163 Mills Road. 7, Wilson Goodwin, 26 Langsford Road. 8, John Green on behalf of Green Marine Corp., 42 Langsford Road. 9, Alex Hebert, Marine Patrol Officer. 11, Carrie Herman, 27 Langsford Road. 11, Kathy Preble Jordan, 33 Langsford Road. 12, Janet Judge, 27 Langsford Road. 13, Julia and Ann Layton, 47 Langsford Road. 14, Amy Llewellyn, 44 Langsford Road. 15, Celeste Marr, 5 Greer Road. 16, Douglas and Lisa Martin, 17 Langsford Road. 17, Rita McCall, 60 Langsford Road. 18, Harold Mooney, 44 Langsford Road. 19, William Noel, 28 Langsford Road. 20, Terry Ridland Stevens, Langsford Road. 21, Edward Sullivan, 25 Langsford Road. 22, Nancy Veman, 14 Agamenticus Avenue. And 23, Barbara and Edward Wright, 18 Langsford Road. So that's the end of Appendix 1, which was referenced in the decision itself. So at this point, I think we would essentially need, if there's nothing else to change about the decision, we would need essentially two motions. One, to adopt the proposed written decision as amended, as the board's decision in this matter. And then, so that would be number one. Number two, if you would like to authorize Mike to sign on behalf of the board, a motion to authorize him to sign. And then, motion second and discussion on each of those.
So I'll entertain a motion to accept the findings of fact as amended.
So moved.
Second,
All those in favor? Aye? Okay. Was that 5-0 or, okay, 5-0. And the second one is, whatever you guys want to do.
I make a motion that we accept Mike as the signer of this application.
Second.
All those in favor? Okay, 5-0. We're good.
Okay, all right. Should I just email it to you, the revised version and then it's dated today, so.
Put it on letterhead. And,
Yeah, to put it on letterhead. Is that possible to do that today, you think, or? Yeah, if I email it to you, yeah, I will do so. All right.
It's probably not possible to mail it today. You can email it, but not.
No, that's fine, yeah. And again, the appeal deadline, or the appeal basically follows from when, the timestamp or date stamp on the mailing or the mailing would be.
But it'll go regular, it's not into. And it goes to the applicant.
Yes.
Correct, not the applicant's attorney.
Well, I would send it to all.
So does Gene, yeah.
Yeah, where they're represented by where they have representatives, I would send it to the attorneys in this. Is that
Yeah.
okay with you, Gene? Okay. All right, I will email that to you.
Done. Good. Is there any other business to come before the board? Then I'll entertain a motion to adjourn.
So moved.
All those in favor?
Second.
Oh, second, yeah. All those in favor? Motion. The special meeting is adjourned.